Sir, with your permission, I rise to move that the bill further to amend the Public Premises Eviction of Unauthorized Occupants Act 1971 be taken into consideration.
मैं आपको अधीर रंजन जी, माननीय मंत्री जी, हाँ, इंट्रोडक्शन रिमार्क तो करेंगे.
Sir, by way of introduction, I want to recall that the public
माननीय
premises...
सदस्यगण, प्लीज. माननीय मंत्री जी.
Sir, by way of introduction, I want to recall that the Public Premises Eviction of Unauthorized Occupants Amendment Bill 1971 was enacted to ensure that we have a system of rules and regulations which can be used in order to ensure that public premises are occupied only by those who are authorized for that occupation. This legislation enacted in 1971 has already been amended on 5 earlier occasions. Honorable Speaker, sir, the government provides residential accommodation to honorable members of parliament, to government employees, officers and other dignitaries. These allotments are for the duration that the designated persons occupy the posts on which those residential premises have been granted. Sir, this residential accommodation is both a perquisite of office and, if I may submit, sir, also a privilege which certain sections of our society, honorable members of parliament, ministers of the government, public servants, central government employees enjoy. Judges of the High Court are also have this privilege, and indeed of the judiciary, and I could list several other categories of entitled, or if I may also use the term, privileged persons. However, sir, in certain compelling circumstances, such as retirement, transfer, deputation, proceeding on study leave, resignations, dismissal, or the ultimate in the event of death, retention of such accommodation is permitted by the Directorate of Estate for specified periods of time. For instance, Honorable Speaker, when a civil servant is due to retire at the designated age of 60 years, he or she are always aware that when they reach the age of superannuation, which is 60, they will be required to vacate the government allotted residential accommodation. And in order to provide a cushion, in order to facilitate that transition, the government has also formulated rules that the designated officer will be allowed to retain that accommodation for 6 months after that date. The period of retention for honorable members of parliament is 1 month. Sir, the attempt of the government and the Directorate of Estate is always to try to provide accommodation to those who are entitled. We have an interesting situation on our hands that even after the entitled persons cease to be authorized occupants, they do not easily vacate the accommodation allotted to them. On the last occasion, when this bill was amended, a period of notice of 7 days was provided. Also, after the notice was provided, the occupants were to be provided a 15-day period, which in order to facilitate and ease that transition with a provision for an additional 15 days. Sir, the general pool of residential accommodation has a total of 15,416 residential accommodations under its quota, sir. 15,416. It is therefore a matter of considerable regret for me to have to mention that currently we have a total of 3,081 cases which are in litigation. Now this constitutes 20% of the overall size of the general pool of residential accommodation. In other words, sir, because there are 3,081 persons in different categories, and I don't want to point fingers, they have not vacated the accommodation to which they are no longer entitled. It becomes difficult for us, sir, to grant 3,081 other entitled persons, including honorable members of parliament, entitled civil servants, the accommodation which is their legitimate due. Therefore, it is intended through this amendment, sir, to ensure three specific changes which will ensure that the occupants will be left with very little option but to voluntarily move out. But let me first explain, sir, as to why this situation is arising. It is arising because that 7-day notice period which the Director of Estates provides, and then an additional 15 days period in 2 installments, invariably results in the unauthorized occupant going to a court and getting a stay order. As a result of which, we are battling, as I mentioned, 3,081 cases of litigation. I would therefore submit, sir, that this legislation, which has been long overdue, therefore we are utilizing an existing provision in the legislation which provided for summary notice, which was introduced for temporary accommodation. In other words, those who were in occupation of premises for a short period of 30 days, though they could be summarily evicted. What we are therefore proposing are 3 specific amendments. The first, sir, is to introduce a new definition in the Act to the effect that residential accommodation occupation. And this amendment that I am introducing before this House, 3 amendments, these are essentially only for residential accommodation. The Public Premises Eviction Act is a broader piece of legislation which covers other public premises as well, such as office space, etc. This does not apply to those categories. The second proposed amendment is to insert a new section in the Act after Section 3A, a Section 3B, to provide for eviction from residential accommodation on a summary basis by the estate officer. The second amendment flows directly from the first amendment, where a definition has been introduced. And the third amendment is proposed. First of all, on the second amendment, a period of 3 days will be the notice period. Sir, when the Act was last amended in 1994, they had, in fact, for temporary accommodation, not introduced any notice period at all. Therefore, that appeared to go against the canons of natural justice. So the idea now is to provide a 3-day period so that the requirements of natural justice are fulfilled. After considering the reply of the so-called unauthorized occupant and making such inquiries as the estate officer deems fit, he will then issue an eviction notice. And sir, the third amendment is again flowing from the first two, that for the period that the unauthorized occupant has been in possession of the premises, because he or she may have got a stay order, damages will be calculated in terms of the period of unauthorized occupation. Sir, I would like to confine myself at this stage to these introductory remarks. It is my submission to this House, sir, through you, that this is a long overdue set of amendments, and we had introduced this in the last session of Parliament, but because of pressure of legislative business, other factors, the bill could not come up for legislative approval. May I submit, sir, this is also a very good time to push through this legislation, because I have several honourable members of Parliament and others waiting to get residential accommodation. And this House will appreciate more than any other body how important it is for us to try and encourage within single inverted commas those of our colleagues who are no longer entitled or authorized, to encourage them to move. And we have been very tolerant, we have tried our best, but I would be very happy to listen to the views of the honourable members. I will do my best to respond to those views, but I recommend that this bill be considered for discussion and eventual adoption. I thank you, sir.